I'll go ahead and read starting with number 4. Petitioners further argue that the 1865 Louisiana law should be disregarded because it was adopted as part of the Black Codes, DR 31 through 33. Black Codes are undoubtedly a relic, and this is the state saying this, right?
That is the official position of the state of Hawaii.
So Barack Obama's buddy is arguing, although the Black Codes are undoubtedly a relic of a shameful portion of American history, I guess that doesn't matter. But that does not mean the laws contained within them are irrelevant to the Second Amendment's historical analysis, because he's trying to couch in the Bruen historical analysis, right? And contemporary opponents of the Black Codes agreed that the Second Amendment did not authorize armed entry without the consent of a property owner. See D.E. Sickles' General Order, number 1. So since when is a general order law? I'm trying to understand that.
Well, it's one not. And more to the point, General Sickle here was, even if we say that it was law, I mean, he was referring to private property that is not open to the public.
Copy that.
Basically, what General Sickles is saying is that the laws of trespass always apply, and you can't carry a gun onto private property that's not open to the public unless you have an invitation because, well, you don't have a right to be there.
It's right? Private property.
Yeah. But a business that opens its doors, open for business, head into the grocery store, there's an implied license to go in there.
Yeah.
Right? I mean,
absolutely.
The supermarket wants you in there. The tire store wants you in there. And in this country, this is going to lead to the state of Hawaii's next interesting argument is in this country, there's always been a tradition that if you have an implied license to enter, then that includes being able to carry a firearm. And here. So as you can see, the state of Hawaii has endorsed the use of these Black Codes. And well, I mean, for many reasons, that's not appropriate. But maybe if we're just going to try and keep it as academic as possible, a law that impacts a very small minority
right,
is not historically similar to a law that impacts everyone.
So was Sickles a Confederate, just out of curiosity?
No, he was a Union general that had just taken over control of Louisiana.
So it says here that he issued a decree preempting South Carolina's Black Codes and providing that while constitutional rights of all loyal and well-disposed inhabitants to keep and bear arms shall not be infringed, nevertheless, this shall authorize any person to enter with arms on the premises of another against his consent. Petitioners also argue that the Reconstruction era precedents came too late. But this court declined review of petitioner's second question presented, which asked the court to decide the relevant time period courts should look to when analyzing Second Amendment claims, and for good reason. The state is arguing there is no need for this court to decide that question here, as in Bruen and Rahimi. The public understanding that legislatures could require a person to obtain consent before carrying a firearm onto private property was the same in 1791 and 1868. But again, you distinguish the difference between private property and a private business that's open to the public, the implied license.
Yeah.
Do you want me to keep reading, or do you think we have enough?
No, I mean, I just want for you to highlight the part about the Black Codes. I mean, we don't have the time. I don't have the voice to go through this entire brief with everyone. But I mean, that's the big thing. And then there's another issue is, assuming this doesn't work, the state of Hawaii is saying that the laws of the kingdom of Hawaii should take precedent over anything else. And, I'll give them their credit. I'll try and lay out this argument since thankfully we have, this sort of format that I can spend a little bit of time on this. So the state of Hawaii is not saying that the laws of the kingdom of Hawaii trump the Second Amendment, but that's basically what they're saying. And here is their argument. The implied license that has always been the case in this country should not apply to Hawaii, because historically, people didn't have the right to carry firearms in Hawaii. Therefore, they didn't have a implied license to carry a firearm.
But Alan, they did historically have the right to carry arms. In fact, ancient Hawaiian law almost commands males to protect women with their paddled, shark-toothed paddles.
Well, according to the state of Hawaii, the most recent iteration of the laws of the kingdom during Kamehameha, especially Kamehameha III.
Right. This guy
you couldn't carry weapons. And that means the history of Hawaii does not have an implied license to carry into public businesses. And so that's a very That's a nuanced way of saying the laws of the Kingdom of Hawaii trump the Second Amendment, right? They just take a couple
Absolutely.
extra steps to get there.
Yeah.
And that just cannot be. There's no area of constitutional law that says that you trump the laws of a state. We should look to the laws of a state or the history of a state to decide a national standard on constitutional law. You don't have more rights in Montana than you do in Wyoming or Washington, D.C. or whatever, you know?
Kind of like a marriage license, right?
Yeah. It's like, let's take a look at and let's take this argument to its extreme. Apply it to a few other places. Alaska was part of Russia up until, I believe, 1856 when we bought it for them. Are we now saying that the laws of the Russian czars apply to Alaska?
I guess only if you're the state of Hawaii.
Well, I mean, if the Supreme Court adopts this position, then that will be the law in all 50 states. Is that
Unbelievable.
We'll have a state-by-state inquiry. That's why I genuinely believe the state of Hawaii cannot win this one, because their position is so extreme that it would destroy the idea of a national standard for constitutional rights. Instead, you'd have just, people, Montana gets to do one thing, Wyoming gets to do another, California gets to do another. And let's look at the territories. I mean, are we really going to require a historical analysis of Puerto Rico's laws or Saipan's law, right? I mean,
Right.
Saipan was, it was in the middle of World War II. I mean, they just very recently became part of the Union. I mean, Guam, America, Samoa. I mean, that's just not how the law works. But that's what the state of Hawaii is putting its head on, is that the U.S. Constitution should not apply if you can show some sort of get some sort of state carve out based upon the history of a place that wasn't even the United States, right? And that just can't be the law.
Right. And in this case, we have evidence that the king disarmed his citizens because he wanted to establish absolute control. I mean, wasn't that the point? Wasn't that the point of this?
Yeah.
The Second Amendment was to ensure that it was memorialized that we had the right to overthrow an unjust government through force of arms if necessary.
That is true. And the bottom line here is the laws of a monarchy have no place in American jurisprudence. You can't.
I know, it's silly.
So that's where we're at. And, they're going to present this to the U.S. Supreme Court. And look, my opposing counsel, Mr. Katyal, I mean, I've argued against him before. He's an excellent attorney. Frankly, he's much better at presenting an oral argument than I'll ever be. He's presented, I want to say, 54 Supreme Court arguments today. He's one of the most accomplished Supreme Court advocates ever. But I have the history of this nation on my side. I have a genuine basis to argue a case that shows that my clients are being disarmed by an unjust law that's completely unrooted in American tradition. And for that reason, I genuinely believe the Supreme Court is going to find this case, is going to find the Ninth Circuit's ruling was completely erroneous and rule in my favor. And as a practical matter, I genuinely don't believe that the Supreme Court took this case to pat the Ninth Circuit on the bat and say, great job. I really don't.